Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. And this is our two-weekly community conference call every other Thursday. Today is October 14th, 2021. Remember that the disclaimers that you hear when you log in apply to these calls. These are not meant to be exact advice, just guidance as best as we can. And also, these do not create attorney-client relationship, amongst others. Okay, let's just make sure everybody can hear me okay. So, one second.
The conference is now in conversation mode.
Can you folks all hear me all right? Hello?
Yes.
Okay, excellent. Thank you.
The conference is now in presentation mode.
So let's begin with answering the questions I consider to be frequently asked questions. Like this one here, re-entering the United States on visitor visa. So if my parents are here and they stay here a full 6 months, can they go out and come back again within the next 6 months of leaving the United States? And the answer is, that's always risky, because if in any 12-month period you have spent more than 6 months in the United States, the government can take the position that it appears your parents or the person using the visitor's visa, they are or he is living in the United States and visiting their home country, instead of it being the other way around. So can they? The answer is, well, it is potentially possible. Should they? I think it will be problematic somewhere along the line. The risk is, at the airport itself, they can be turned back. So without letting them come to the United States, they would be turned back. Okay? Please press star 5 if you have a follow-up question on this issue. Press star 5. Okay, let's go on to the next frequently asked question. So this is also another one that gets asked a lot. Can green card employment authorization holders start a business, and what impact accrues on their pending I-485? Okay, so the set of questions that flow from that situation are as follows. I guess their I-485 is pending, and the question is, can I start my own business on the side? So first question is, can I run my second W-2, which is an employee-based taxation? Can I run my second W-2 for my own company, keeping my primary W-2 with the same employer who filed the green card? And the answer is yes, but. And what is this but? The but is that if it appears that you intend to leave your primary employer, that militates against your required intention of continuing the green card job indefinitely. Not permanently, indefinitely. In other words, you don't have any firm plans to leave. So if your situation, again, I would advise you to talk with a lawyer, your own lawyers preferably. If your situation is such that having a second business in no way contravenes your intention to continue your green card job, you're okay using it to do another job or to have your own business. What kind of questions can they ask you in the interview? Whatever questions they ask, it is your right to do so. And the only focus of the inquiry USCIS should take is whether or not you have the intention to continue working with your own employer, the one who filed your adjustment of status. And that should be their focus of inquiry. It shouldn't matter to them whether you have one side business or 10, or even if you have a second job. I hope that makes sense to you guys. The last question is, if I start a business on Green Card EAD, Will they deny my I-485? I just pointed out to you what the grounds of denial could be. If I-485 is denied, we can come back to the H-1B again. But do we have to refile the I-485 again? And the answer is you should be able to file the I-485 again unless the government is sold on the idea that you have terminated your green card by destroying your intention to work for the employer on an indefinite basis. That's a very tough decision for the government to make. Not an easy one. I'm not that worried about it. But if they didn't, let's say they deny your 485 based upon the fact that you have destroyed your intention to continue working for the same employer who processed your green card, and you have lost that intention to work for them, that 485 denial would require you to start your green card all over again. Personally, I have never known of any case such like this, and I don't think it should ever happen. But theoretically, at least the possibility does exist. *5 if you have a follow-up question on this. Press *5 on your phone if you have a follow-up question on this. No new questions, please. Area code 612, where are you calling from?
I'm calling from Chicago, sir.
Yes, sir.
My
Go
name is
ahead.
Sandil.
Yes, sir.
I was the one who posted this question.
Yes, sir.
So I said in the first thing, right, keeping my primary W-2. So it's not a future employment. I'm currently working for the primary W-2 with the same employer.
Right.
All I'm to understand, like, can I start my business and run my payroll?
Sir, everything I answered doesn't matter whether it is a future employer or a present employer. The basic law is the same. So I've already answered those questions. What else?
Yeah. So basically, like, right now I got approved, on EB3. If you want to go back to the EB-2, then do I have to be in H1 or can I be in the EB3 category?
Okay, that question is unclear. I think what you're asking me is this. If I start using my EAD under EB3, can I later on upgrade to EB2? I don't see why not. Okay.
But they said, I have to be H1 to upgrade to EB2.
No. I disagree. Okay. As long as the EB2 dates are current. So I'm assuming your PERM was filed as EB2. Then your I-140 was either filed or downgraded as EB3. In such a scenario, you can always go back to EB2 if the dates are current. I see no problem. Okay?
Okay, sir.
Good luck.
Okay, thank you.
Okay, next frequently asked question. Oh yeah, this is another one. This has been a very confusing issue for not only employers and employees, but even lawyers. Is there a problem listing one location in a PERM application while living and working remotely in a different location? And the answer is no, it is not. No problem, as long as the following two conditions are kept in mind. The first one is easy. Green card is for a future job. I could be working for IBM in California and Sun Microsystems in Seattle could be filing my green card. I'm living in a different place. In fact, even I'm working for a different employer. So if I have the intention to join the location listed on my PERM, either sometime before the green card approval or after the green card approval, there is no issue in having a different location in PERM. So once again, you could be working in location X and the PERM is filed for location Y. As long as you have the intention to join the location Y, you can file even though you are currently working at location X. That one is easy. Future job, future location, perfectly okay. Oh, by the way, interesting thing is, even in this scenario, once the 485 is filed and the I-140 is approved, after 180 days of the 485, you can choose to be wherever you want to be because you're allowed to port your green card. The only requirement is when you start the PERM, file the I-140, file the 485, Your intention throughout was to work at location Y. But after 180 days, if the intention changes, it is absolutely no problem. Okay. Second scenario, and this is very common, this is where most of our cases are. When you have consulting jobs where you could be moving from month to month, 6 months to 6 months, a year, year and a half, no predictability where you are going to be, it is normally recommended and legally allowed to file the PERM application as though your job is located in the corporate headquarters or principal place of business. So let's say that your employer headquartered in Chicago, but your job is today in California, 7 months later in Washington, D.C., a year later in New York, you would file through Chicago, even though you are working all over the country. So that is the answer. Now let's see if there was anything else. Okay. Yeah, so I have pretty much covered the law in the questions that you have asked. Press *5 if you have any follow-up questions. No new questions, just follow-up questions on this issue. Okay. The next frequently asked question is EB2, EB3 options in PERM filing and EB2 to EB3 downgrade and upgrade. Company is filing PERM in EB2. My priority date is 2013. Question 1. If the priority date is current in EB3, then my I-140 and 45 can be filed EB3. But you said that after EB3 will come, then I should file I-140 and EB2 also to cover EB2. Not sure about the whole concept. So you are confused about this concept. Well, it's not that difficult. Let me explain. Think about it this way. You can always downgrade if you start your case in a higher category. But if you file your case in the lower category, it's not possible to upgrade without refiling. What does that mean? It is the PERM application which decides in the first instance what your case is capable of becoming. So if you file a PERM application as an EB2, you can always downgrade to EB3 at the I-140 stage. But if you file the application as EB3, you cannot upgrade. Okay? Then you'll have to file a new PERM under EB2. So let's say you filed the PERM application under EB2. At the I-140 stage, after the PERM is approved, it is advantageous to file the I-140 under EB3 category. You can. If you already have an approval of I-140 under EB2, you can downgrade also. Okay. Now, let's say that EB3 was downgraded and all of a sudden EB2 becomes advantageous. Can you go back to EB2? Sure, absolutely. Many of the cases, as I had indicated, if we feel that EB2 would be of better advantage as well somewhere along the line, we might even file a second I-140 for EB2 using a copy of the same PERM that previously got us the EB3. But this is only possible if your PERM was filed as an EB2. If the PERM was filed as an EB3, you have no choice but to file an EB3. I hope that makes sense to you. Can I-140 be filed in EB2 and EB3 together? And the answer is yes, although I like to do it separately for several reasons, most of all to avoid confusion. But now the government is well aware of these downgrades. I think you could file both of them together as two separate filings. If my PERM is approved and should I wait for priority date to change file I-140? How long? I've already covered this. My company attorney told me that once downgraded to EB3, then I can't upgrade to EB2. They must be saying something different. That's not true. If your PERM was filed as an EB2, I-140 was approved as an EB3, you can always go back to EB2 by filing another I-140 under EB-2. Okay, but if you already have an EB-2 approval I-140, you can, after you have filed for EB-3 downgrade, still go back to EB-2 if you so like. So you're not committing irrevocably to EB-3 or to EB-2, and you can switch one from the other anytime you like. Star 5, if you have a follow-up question on this. Star 5, I hope I've cleared some of the confusion around this. Star 5, if you have a follow-up question. Okay. Let's see the next frequently asked question. All right, there doesn't appear to be any more frequently asked questions. Then let's go to the regular questions. Interfiling from EB3 to EB2 and working on H-1B and E-1B EAD simultaneously. This is question number 2. I filed 485 downgrade from EB2 to EB3 last year, received EAD, completed biomedicals, medicals submitted, moved to a new employer on H1 after 180 days, filed 485J supplement. If EB2 moves faster, can I interfile from EB3 to EB2? Yes, you can. Should you file a second I-485? And the answer is the jury is still out on that one. Talk to your lawyers what the thinking of the government at that time is. You really don't have to file a second 485. The same 485 can be used for interfiling, but in some cases it may make sense to file a second I-485. Nothing illegal about it. While I'm on H1, can I work on a secondary job on EAD? Yes, but you cannot maintain H1 and EAD together. If you start using EAD, H1 goes to sleep, so to say. If I used EAD, can I still interfile from EB3 to EB2? I've always struggled with this idea that you cannot interfile just because you've used your EAD. I don't know where this comes from until I hear something or read something more definitively. My opinion is you can interfile even if you've used the EAD. Okay. Star 5 if you have a follow-up question. No new questions, please. Any follow-up on this? Okay. This question is easy to answer. Question number 3. Can I renew my visa within the United States? No, you cannot. You can extend your status, but you can't renew your visa, which is what you're asking. Like a Dropbox or anything. You can't do it within the United States. Star 5 if you have a follow-up question. Star 5. Okay. This one is area code 609, which I believe is New Jersey. 609, where are you calling from?
Hi, I'm calling from New Jersey. My name is Karthik here.
Yes, sir.
I'm sorry, you asked the question that interfiling from EB3 to EB2. That was my question. I have one question to ask.
Okay, hang on. I am now on the B2 question.
Sorry.
Okay.
Oh, sorry. Okay.
Yeah, I'll take it back to the interfiling question, but please be quick because I have to move on. Go ahead. What is your question?
Okay, no issues. Thank you. My question was that if I use EAD, you said that we can still interfile from EB3 to EB2,
yes, sir.
So I don't have any issues in that.
I believe
Okay,
so.
Sure, thank you.
I believe so because I've heard other lawyers say this also. I see no legal reason why it cannot be done. I am still to hear any legal explanation for the doubt and sometimes even the opinion lawyers have that if somehow you have used your EAD, you cannot then ask for an interfiling from EB3 to EB2 or EB2 to EB3. I think that's just not true. Okay, but of course, if USCIS, this is definitely a tertiary issue of law. The only reason I think it could ever come about is if the government says, well, you have to have maintained status in order to upgrade or downgrade through interfiling, but If you have used your employment authorization, you no longer have status, you are in authorized period of stay. I think that's ridiculous. I don't think that applies in such a case. And I think if we took something like that to court, government will have a very hard time explaining to the judge the reason for this extremely unreasonable interpretation. So in my view, it can be done. I don't think it should be a problem. Okay?
Yeah, thank you. One last question, sorry. Thank you. See, the EAD which I already filed, I got my EAD card, and within 6 months I filed for extension, and there is the auto extension for 180 days.
Right.
What if the USA does not approve the EAD even within 180 days of that?
Yeah,
Then
you are legal to stay but not to work. You can legally stay in the USA because your 485 is pending, but you cannot work. So somewhere before the end of the 180 days, it might be worth it to maybe even get an H-1B, get it stamped and come back in, because then you're back on H-1B, no problem. Or you can always sue the government. That's an absolutely unreasonable period of time for an EAD to be pending, and you might be able to convince a judge to have the government move on it. Okay?
Okay, sure. Thank you. Thank you very much. I appreciate your time.
You're welcome, sir. Good luck. Okay, so back to B2, there was no issue about the visitor's visa. EB-1C processing time. So this is the international managers category. My EB-1C was filed November 2022, priority date pending. So priority date's just been pushed back. Do I have to wait till the receipt date? For my inquiry passes my priority date to inquire USCIS. Do I have any other recourse? Look, I don't think I can answer these questions. These are all fact-bound questions. I can tell you this, that just inquiring into the status doesn't do anything. But if your case has bypassed normal processing times, opening an inquiry is a good idea. Otherwise, no, it isn't. Are there any other avenues? Yeah, congressman, ombudsman, these are the typical cases. Have you recently encountered EB-1C cases filed after November 2020 being approved? I wouldn't know, sir. Not off the top of my head. We do so many cases. I know this, that many EB-1Cs have been approved in the past few weeks. So were they filed after November 2020? I assume so, but I don't know for sure. *5 if you have a follow-up question. *5. Any follow-up questions on EB-1C? Okay. The next question is number 6. Concurrent H-1B and employer change. I'm on a cap-exempt H-1. I also have a concurrent H-1. Now I found another project who filed my lottery. That got approved. Congratulations. What will happen to the concurrent H-1 if I switch to the new cap subject H-1? I'll have to study this. I do not know the answer off the top of my head. Okay? Because concurrent to what? Concurrent to a pre-existing H-1. So now your concurrency has changed. I do not know the answer. I'm very, very sorry, Rick. But my guess, this is a guess. My guess is that the concurrent H-1B should still hold good. Do I have to immediately switch to my cap subject H-1? Well, that's something you should be discussing with your lawyers. There are several gray areas there. How far can the employer accommodate you? How far can you be accommodated? Technically, an H-1B approval does not require you to join the employer if you don't want to join them, unless you've signed a contract. That's a different issue. But there are several areas here that I can't really get into without knowing more facts. If you don't join the employer and they legally can accommodate you, your H-1B has been approved with an I-94, you are no longer subject to the quota. Okay. If I'm relocating to a different place, current employer is filing amendment, should my concurrent H-1 also be amended? I do not believe so. If the terms of the concurrent H-1B, this is my understanding, I'll have to of course look at the regs. My understanding is if you have a main H-1B and a concurrent H-1B, And the concurrent H-1B is maintaining its particulars, but on the main H-1B, let's say you are changing the location or the client, that amendment would not affect the concurrent H-1B, which should continue without any problem. Okay. In general, how many days can H-1B worker be outside of the United States and continue working? Well, I have an author page on the in the Economic Times. Okay, I wrote a brief comment there. It is also on our blogs in immigration.com. That government thinks if you want to maintain the continuity of your H-1B, you must be paid H-1B salary even if you're outside the US. I think that's ridiculous. Why? Because there are intermittent H-1Bs. You could come to an H-1B job 10 days in 3 years. That's okay. You still maintain your H-1B. So I'm not sure the government has this right, but it's a long and complicated issue. It's not a simple answer. If you ask my opinion, you're getting paid your H-1B salary. You could be outside the USA all 3 years if you so choose. Okay. Now, should you be paid the H-1B salary under the H-1B conditions? I don't think so. But the government says, no, you have to be. I think they are wrong. And they will, somewhere along the line, lose a lawsuit. Okay. *5 if you have a follow-up question. *5. Okay. Area code 513. 513, go ahead. Where are you calling from?
Hello, sir. I'm calling from Cincinnati. I have a question in the similar line. So okay. I'm on initial OPT, which expires on November 30, 2021. But recently, my previous employer filed an H-1B for me, but it was withdrawn in the month of May. But it still happened to be withdrawn yet. And I had to file my STEM OPT extension, but it was denied recently, saying that your H-1B is approved. It's been 4 months. It's still not been withdrawn. I asked my school what to do. They are like, you need a withdrawal form to open your service record. I can't. Otherwise, reapplying for STEM OPT wouldn't be any worth of it. And my employer says, previous employer attorney says, we don't have a withdrawal form. We can't help you in that case. We still need to wait. This is a patient's game. So I feel in a helpless situation. And I don't know what to do at this point.
Well, this actually has nothing to do with what we just discussed. You should hold off on all the new questions till the end of the call. Since we have spent time on this, I will just tell you this. The only thing you can do is, other than filing a lawsuit, open a ticket with the Ombudsman's office. Because this is definitely an issue where two agencies, different procedures are causing you problems. ICE, who maintains the SEVIS, and USCIS, who maintains the H-1Bs. So open a ticket with the USCIS Ombudsman's office, or call your local congressman. Congressman is better and more effective. Okay?
Sir, just a follow-up question. So I already raised the question, raised the request with my congressman, but I'm still worried that would this happen in the next 45 days? If not, my school said if this doesn't happen, all of this in the next 45 days, then I have to leave the country. I'm just a student. I'm still on my initial OPT, nothing else.
Right.
H-1B with the conflict.
Right.
So
follow up with your congressman. They can get it fixed a lot quicker than 45 days. Okay?
Okay. Thank you.
You're welcome.
I have another. Can I?
No, I will not indulge you anymore because I have a lot of people waiting. Sorry. Wait till the end of the call. If we have time, we'll go over the other questions.
Sure.
Okay. Area code 908. Let's see. 908, New Jersey. Go ahead, please.
Hi, Rajiv. This is my question, and thanks for answering those couple of questions.
Yes,
but
sir.
Just to give a clarity on number 2, so they filed the employer filed my cap subject H1, but the project is on hold, so I didn't join them yet.
Okay.
Because
that's actually
some
that's actually illegal for the employer, because if you are willing to join, they have to start paying you. Okay. They can't put you on hold. That's illegal.
Sure. And then just to add another thing, so they told me that my H1 got approved and I can see it online, but they didn't send me the document. So I was just wondering if I have to go to lottery again if I file next time if I find another project. Can I continue? Or can
what was the start date of that H1?
October 1st.
Yeah. So once October 1st passes and your H-1B has been approved with the status I-94, etc., you are not ever going to go through the lottery again, at least not for the next 6 years. Okay?
Okay.
Good
And
luck.
number 3,
Yep.
just to expand that. So my concurrent H1 is filed for the work location as same as my home location.
Right.
Now my home location is going to change.
How
so
far?
I think it's still okay.
How far is it?
From Minnesota to North Carolina.
You definitely have to file an amendment. Okay?
For the concurrent?
Yes, sir.
Okay.
Good luck.
Thank you.
You're welcome.
Bye.
Bye-bye. Okay. So next question. Does CSPA apply for parents with a K1, K2 visa? I don't remember off the top of my head, but this is what I do remember. Please have it double checked. I do remember that if the K2 holder is still under 21 when they enter with their K1 parent, that K2 holder is not subject to to 21-year limitation. So once again, if they enter the USA on K2 before they turn 21, they should be okay. Have it double checked. This is a complicated area of the law, and I'm speaking from memory rather than confirmed review of regulations. So you did not bring your derivative in. He would be aged out by April this year. This year means 2021. Are you here? Press star 5 if you're here. Press star 5 if you're here. This is not clear. I'm not sure what you're asking me. So what I told you applies from what I remember. If they are under 21 when they land on K2, they are not subject to the 21-year-old limitation anymore. Okay? Good luck. Let's go on to the next question. So change of jobs with approved PERM and I-140 from employer A to employer B. Oh yeah, employer B has DOJ issues. They have some investigation going on. Okay, you got an approved PERM I-140 from employer A. Okay, you're currently working for them on H-1B. But you want to change jobs. But the company that you want to go to has some lawsuit by Justice Department. And they have not received any PERM approvals. Now if I move to company B, and if the dates become current, are there any timelines to file for I-485? No, there are not. The only problem is if you want to extend your H-1B based upon I-140 approval, you might have to explain to the government why you have not filed a 485. Okay. Other than that, there is no deadline. If employer B has issues with DOJ, DOL, will I lose my priority date? No, you would not lose your priority date. The only way you lose your priority date is if the government revokes the employer A's I-140 approval for fraud or gross error or something like that. If employer B files for PERM, what happens if the PERM application is pending or denied? What are the impacts on my green card process? You need to talk to your own lawyers. This is a discussion they used to, you should focus your questions for me. This is a very long discussion. What are the impacts? That's like asking a doctor how many ways can I fall sick. There are too many ways for me to go over in this call. The answer is if employer B files for PERM, I think this is a dangerous situation. I don't think you should move. If they have a DOJ, DOL issue that has not been resolved, you could be stuck, but it does not affect your already approved green card, I-140. Okay. Star 5 if you have a follow-up question. Star 5. Okay. Can a misdemeanor affect my green card application? The short answer is usually no. Okay, but it's very easy to make mistakes in this area of the law. So instead of giving you exact advice, what I'm going to suggest is this. Speak with a lawyer in the location where the crime allegedly occurred, and that lawyer should be the type of lawyer who does deportation defense, because they are familiar with the state criminal statutes. We can study them for you, and we can examine the impact on immigration law, but it becomes very close to almost like an unauthorized practice of law issue. I should not be commenting upon Illinois law when I'm not admitted in Illinois. So get yourself a local lawyer who does deportation defense. Usually, misdemeanors are not a big problem as long as it is a single misdemeanor. Okay, but there are issues. For example, some states have something called aggravated misdemeanor, which can actually be a problem. But these days, the focus more is on the sentence actually imposed. So I'm not that concerned about it, but talk with a local lawyer. Okay. Yeah, you need to talk with a local lawyer. So this case is very confusing. Nataraj is, at least it's very confusing for the USCIS. They are not sure which I-140 he is going with, and they keep making this mistake. Best thing for you, just go to the local congressman's office. Okay, they are the ones who can get this fixed, and don't hesitate to do that. They are pretty effective in cases like this. Okay. Alok Mishra, some problem with posting it. Let's see. I can't read this. With employer 1, my current employer, I have approved EB-2 I-140. I downgraded in October 2020 to EB-3, applied 485 concurrently. EB-3 I-140 is also approved. 180 days have passed. Okay. 180 days have not passed since EB-3 I-140 approval. That does not matter. Once the EB-3 I-140 is approved, as long as the 485 has now been pending 180 days, you are okay. You do have to submit supplement J. Employer 2 does not have to do PERM again. If the priority date becomes current under EB-3, my application will be picked up, yes. If my priority date becomes current under EB-2, what will happen? I think you'll have to ask for the government to interfile, and you probably will have to file a supplement J for the EB-2 application, because supplement J may not be applicable to a job. But if it's the same PERM application for both EB-3 and EB-2, then I don't know if you should need a supplement J. It's an area of the law on which there is no definitive comment from the government as far as I know, but it shouldn't be difficult to deal with. Okay. *5 if you have a follow-up question on this, Mishraji. *5. Area code 615. 615, where are you calling from?
Hey Rajiv, thanks. I'm from Philly.
Okay, I can't hear you. Could you speak up a little bit?
Yeah, I'm from Philly. Is it better?
Nope, still pretty bad. I heard that you are from Philly, but I had to strain really hard.
Okay, is it better now?
Just shout in the phone.
I just
shout a little bit.
Okay,
it's okay.
Is it better? Is it better?
Little better. Go ahead.
Okay, so just coming to point number D, so the new employer will have to do the interfiling, right?
Interfiling is your job, because the 485 belongs to you.
Okay, so I just have to work with my existing lawyer.
Yes, sir. Yes, sir.
Okay.
Okay?
Thank you so much.
You're welcome. Good luck. Okay, let's go on to the next question. What? Oh, this is confusing. H-1B. Oh. Somebody else raised their hand. Area code 267. Where are you calling from? Hello? Okay, looks like a mistake. So H-1B OPT travel and re-entry for parents, maintaining H-1B, concurrent I-140. Wow. I'm on OPT. Can my parents stay in USA, visit for 6 months, then out of country for 2-3 weeks? I just answered that question. No, not a good idea. Is it a good idea to not apply for H-1B, continue on OPT for 3 years because I can get my green card within 3 years? By the way, I do have a comment on this, both on my blogs on immigration.com as well as on my author page on Economic Times. So if you just Google Rajiv S. Khanna space Economic Times, you should be able to pull my articles. One of them talks about applying for a green card directly from student status. It is certainly possible, okay, for somebody who's not born in India. So talk with your lawyers, discuss all the issues. You should still be applying for H-1B each year, just in case you need it, okay? And you should be able to file I-140 and 45 concurrently if the dates are current. How long will it typically take? Nobody can tell you that. Jobs are similar or not similar. Software developer versus data scientist, hard for me to say. I have to look at the jobs. But the same or similar descriptor is fairly charitable. They're not that strict about the jobs being absolutely the same. Again, this is between your lawyers and you, not somebody like me who's trying to make a snap judgment, but it's certainly possible. Can you please explain when can an employee change an employer or change his job? We have it in our frequently asked questions on immigration.com. This has been discussed in detail. Basically, if your I-140 is not approved, you get nothing. But if your I-140 is approved, you still have to start the green card all over again, but you carry your priority date, which may not be of any use to you because you were born in a country other than India, one of the backed up countries. So in your case, I would say that it doesn't. The real advantage happens when the I-140 is approved and 485 has been pending 180 days. If then you change your jobs, you don't have to redo your green card. Okay. *5 if you are here. I can wrap up any follow-up questions you have. *5. Okay. Oh, so somebody asked me, and there was a good question. I can see how it is confusing. So they said if somebody has a 10-year bar because they overstayed by a year or more in the United States, I have two different opinions. At one point I said, after 10 years, you can apply for a tourist visa and it shouldn't be a problem. And in another place I said, you can apply, but you still have to convince the government that you're a good guy and you're not breaking the law again. And both of these are correct. The complete statement is, after you have been outside for 10 years, you're no longer subject to the 10-year bar, but you still have to prove that you are entitled to the B2 visa. And it could be difficult because you have a past record of breaking the law. Okay. *5 if you have a follow-up question on this, press *5. Okay, let's see if we can do any new questions in the next 15 minutes. Anybody who has a question, press *5. Anybody who has a question? So there's 6 people with questions. I'll try to do the best I can. This one is an anonymous person. I don't know where they're calling from, but they logged in pretty early at 12:21 p.m. Hello? I can hear a dog barking in the background. Hello?
Hello.
Yes.
This is Cspa speaking.
Yes.
I have a question. My H1 cap was approved last year, but I didn't receive the approval notice. During pandemic, the postal was not received. It went back to USCIS. So, and one more thing is my case status is not updated in the USCIS website. Later we applied for premium. That time we came to know that it's already been approved. So again we applied for to get the duplicate copy by filing I-824, but it's been 5 months. There is no updates on that. What is the possibility, any other options to get the approval notice?
Yeah, you should, if you have tried everything else, try contacting your congressman's office. That's what I would recommend. And actually, it's actually even better if your employer contacts their congressman's office. They might be able to get quick
directly they can go and they are in Texas. Even mine was filed in Texas, USCIS. Can they directly go and meet, or we need to take any appointment or something?
There is a protocol for congressman's office. You can go to their website. They'll tell you how to contact them. Okay.
Okay.
All right. Good luck.
Or is can we go for any one more amendment for changing wage changes or something, and then go for premium to get the one more approval notice?
You can.
That's what my current lawyer is saying.
You can.
Instead of waiting so long, it's 1 year wasted.
Mm-hmm.
We can go for amendment with the wage change with the premium process and get the approval notice. Is that option? Will there be any problem?
I can't predict if there'll be any problem, but that's certainly an option. I don't see any problem with it as long as it is genuine.
Okay. Okay then. Thank you so much.
You're welcome. Okay, let's see. Area code 903. 903, go ahead, please.
Hi, Rajiv. My question is related to the current November visa bulletin where the dates retrogressed for EB3. So my downgrade application was filed and I got my EAD. So I was waiting for the green card, but the dates retrogressed. Now I'm thinking of what are my options in terms of if the dates take too long and I want to change jobs. Can I do that? First thing is with filing 45J when the green card visas are not available. And second question is that if I do that and EB2 dates get better, then can I interfile without being with my green card sponsor employer?
I've already covered that issue several times today, and the answer is yes.
Okay, sir. And sir, just one advice, last advice is, do you recommend staying on H-1B while this green card dates get current?
Yes.
Or is it okay to switch to EAD?
I prefer everybody maintain their H-1B.
Okay, sir. Thank you.
You're welcome. Good luck. Area code 267. Where are you calling from?
Hi, good afternoon. This is Shivani and I'm calling from Philadelphia.
Yes, ma'am.
Okay. Follow up to the previous question from the previous caller. So October 2020, both like my husband is on his own H1, I'm on my own H1. We both have approved I-140s on a EB-2 category. My husband is ahead in terms of priority date. However, because he changed his company, he wasn't eligible to immediately apply in October. But since I was with the same company with approved I-140, I went ahead and applied as me primary and my husband second, dependent. And although I had to downgrade my I-140 EB-2 to EB-3, the status for I-140 is not approved as of now. I have not got my EAD. I just returned from a fingerprint this morning. So my fingerprints are done, and my husband's fingerprints were ahead of me. Actually, he got fingerprint biometric sooner than me. But either way, at this point, we both are done with the biometrics. 140 unapproved, and today I get to know that EB3 dates have retrograded. And in the meantime, what was happening was my husband contacted his previous employer and somehow convinced to go back to his previous employer. And their attorney, although there were mixed answers, but their attorney suggested filing a new 485 with a cover letter where we will, give the case numbers from, my filings and say to switch switch him as primary and me as dependent there, and they were planning on refiling, filing it again from his company. So at this point, we are under EB-2, his priority date is 2010, and now that I've downgrade, although this is not approved yet. So now with the dates going back, is it a good idea if my husband applies? Continues to go ahead and apply, because as of now, even November bulletin, his
Ma'am,
dates are correct.
I'm going to have to cut short your questions. I have a bunch of people waiting. The answer is it a good idea for him to apply under EB-2? Yes. Okay.
Okay. Will so there anything? So do we have to add? Do I have to let attorney to add anything apart from the cover note where they are planning on?
This is a fairly undocumented procedure. So pretty much anything the lawyers do can be wrong or can be right, but it shouldn't matter because it is allowed. Okay.
Okay.
Good luck.
And
I gotta go. Question. Sorry. Area code 908. Go ahead, please. Keep it short, guys. Got a bunch of people waiting. Yeah. Go ahead.
Rajiv, this is a follow-up to my earlier question on the concurrent visa. So the CAP subject H1 that the new employer filed, they didn't send me the document because I don't know for what reason. But you were talking about the I-94 number or something. Where would we find, or how could I get the document?
You see, unfortunately, the problem is you're not entitled to the approval. Well, did they give you a copy of the LCA that they filed?
Yeah.
Because they are required by law to give that to you. I believe they are also required by law to give you a copy of the approval notice. At least that's my understanding. Or that's what I would claim.
Yeah, I was reaching out to them, but they were not responding. So I don't know if
okay. So
what happened there.
I'm trying to think of the best way you can get at least some idea of your approval notice.
So there is something on the USCIS website to request a notice or document if it's missing or not received.
Yeah, they probably won't give it to you. But what you could do is, I think you can take a multiple avenue approach. First thing is, call your lawyers, the lawyers who represented the employer and you.
Okay.
Ask for a copy of the approval notice. Okay.
Yeah, I did that, and then the attorney said that it will be the case manager who would be able to, and she told that case manager would receive the copy, and she's the one who would receive it, and she told she'll talk to the case manager, and I did also email, but there's no response.
I would put it in writing. I will email them, and I would say that I requested a copy of the approval notice, and so far all I've heard is that you are referring me to somebody else, but you should have a copy in your records that you should give me. I don't even know whether I have an H-1B approval and from what date. So at least in Virginia, that would be unethical for me to hold the approval notice from the employee. I cannot. Even if the employer wants me to, I cannot.
Sure.
Okay? And I'm not going to break the law for anyone. So therefore, I think the first approach is to contact your lawyers and put it in writing. Number one. Number two, I would open a ticket with the Ombudsman's office. Say that there appears to be no mechanism for us to receive at least a copy of the approval notice, even if it is a courtesy copy. So could you please arrange for us to get a courtesy copy of the approval notice? The reason I like the Ombudsman's office for this, because they are supposed to take care of the system issues. So this is a system issue. Bad workflows. They should be giving us a copy. Okay? So those are the two things I would do if I were you. All right?
Okay, thank you.
You're welcome. Good luck.
Yeah, bye.
Bye-bye. Area code 303 from Colorado. Go ahead, please. Area code 303.
Hello, Rajiv.
Hello, sir.
Hello, Rajiv. Hey, I have a question on behalf of my sister. She has tourist visa along with my parents. We all have tourist visa, and my sister's fiance is here already on H-1B. His visa got picked up from lottery, and he's moving from F1 to H1. So she wants to get married here because of some problems with the slots. Her fiance is not able to travel India for marriage. Is it legal on tourist visa to come to US?
Yes.
And get married?
It is legal for her to get married, but tell her not to try to convert to H4. Go back to home country. I'm assuming that's India. Apply for H4 visa and come back. It is legal to get married. I don't see why not.
Okay. And even if she has to convince on port of entry, she can clearly mention that she plans to get married here and then come back.
Yeah, she should. She should tell them that, by the way, I also have marriage plans, but I'm going to go back, get H4 visa stamping. I thought you said she's already here, right?
No, she's in India along with parents, but because they want to utilize next month for marriage, so they want to make travel plans.
So I think she should definitely disclose it at the port that she also intends to get married, that her fiance is not able to make it to India, but that she's not going to change to H4. She'll go back to India to get H4 visa stamping. Okay.
All right.
One thing I would recommend is, because this is a little dicey, I think she should clear immigration in Abu Dhabi, so that if there's a problem, they turn her back from Abu Dhabi, not from USA. Okay.
Okay.
Good luck.
Okay. All right. Thank you.
You're welcome. Okay. Area code 303. Where are you calling from? Area code 303. Oh, I think we are done with that one. Area code 609. 609.
Hi.
Hello. Yes. New Jersey.
Yes, I'm Siddhavan Karthikeya. Yeah. Yeah, only one more question. You already answered me regarding the EAD interfile from Eb3 to Eb2. But should I be with the same company, or even if I already moved to new company?
You can't. I think that's where the problem is. If you are with a different company, I don't think you can upgrade, because you will need the EB2 job offer open in order to upgrade, as far as I know. Okay. I haven't given.
But my EB2 firm, but the EB2 firm and I-140 approved for more than 180 days. It's still.
More than 180. Yeah, then you should be okay. If it is more than 180 days, you should be able to use it. No question.
Okay, so even though I moved to new company, and if it is more than 180 days approved days, I can still interfile, no issue.
That's the way I read the law. Yes, sir. Okay.
Yeah, thank you very much. I appreciate you.
You're welcome. Good luck. Area code 813. I don't know where that is. 813, where are you calling from?
Hello, sir. My name is Rupinder. I'm calling from Tampa, Florida.
Punjabi lagde ho, bhai sahab.
हाँ जी बिल्कुल सरदार आ गई थी पंजाबी
सरदार भी बड़े फ्लेवर दे आंदे ने एक ते पंजाबी सरदार ने दूजे दिल्ली वाले ने ओ पक्के सरदार नहीं हैगे
I've been talking to you, listening to you for so many years.
अच्छा
and it's always a pleasure talking to you.
My pleasure जी दसो what's going on?
I have two small questions. One is I have already filed my adjustment of status back in November 2020. And inquiry date as of now is already been exceeded from my receipt date for all the three file applications, which is 765, 131 and 485. Not 485, sorry. Only for 765 and 131. So my question was like, does it take some time for that to get this approved, or is there any time frame after the dates are exceeded?
There used to be a hope in us that there was a limit to these times, but USCIS has proven us wrong. Things are so inefficient right now that there really is no time limit. Okay, so you can keep trying, and that's all you can do. I think the most powerful is the Congressman's office. and the second one is the Ombudsman's office. So these are the two agencies I would fall back upon if I were you. Okay.
Okay. And the last question is, suppose during this filing status, if we are traveling to India, which of the application gets abandoned and which remains intact?
Your advance parole gets abandoned. Your EAD does not get abandoned. So when you come back, you'll have to apply for advance parole again. Okay.
Okay. All right. Yeah.
Good
Thank
luck.
you so much, sir.
Good luck. Okay, I think this is the last one for the day, which is area code 513. 513, where are you calling from?
Hello, sir. I'm Akash. This is a follow-up question again towards my STEM OPT, which was denied. You said me to contact Congressman, which I already did. And regarding the Ombudsman, is that something which I should do, or is that something that the petitioner?
You can do it. It's write it down. It's the Ombudsman. OM as in Om. Okay. Bud as in buddy.
Okay.
Put an S after that. Ombudsman as in man, woman. Ombudsman is one word.
Okay.
Ombudsman is the USCIS Lokpal. Remember in India they were trying to get a Lokpal? So Lokpal is Lokpal is a watchdog agency who watches over USCIS's functioning and reports to Congress. Actually, I have written an article on this, a comment on this in Economic Times just a couple of weeks ago. Go to the Economic Times, go to my author page. Just Rajiv S. Khanna, Economic Times, you should be able to pull it out. It gives you more details about the kinds of cases where I find the Ombudsman's office is very helpful. Okay?
Okay. So just one last question, that would be, since this is since both are also a waiting game, and do you think I can go any further direction to for my STEM OPT approval, because I have all the evidence?
The problem is, short of a lawsuit, what you are stuck with is not a bad case, but bad procedures. Okay. It's the government's procedures that are coming in your way. So therefore, the only way around that is somebody who can cut through the red tape. And there are only two agencies I can think of: Congressman and Ombudsman. Okay.
Can I join any other school in the meantime in the 45 days?
That I do not know. You can ask the transferee school and the transferor school where you are going to. You can ask both schools. Can you go? I think so. The problem is, you said they need the withdrawal letter. But you can check with the school, okay? Check with the school that you want to go to, talk to their DSO and say, look, I've got this problem. It doesn't hurt to check with them, okay? So can you do it?
Okay.
Theoretically, at least, yes. Practically, I don't know what the issues are. Okay.
Okay. Thank you, sir.
Yeah, another one is just Google the one word, study in the States. One word, study in the States. There is a website, I think it's dhs.studyinthestates.gov. They actually have a lot of procedures. They have the procedures that the DSO is supposed to follow, procedures that the student is supposed to follow. In other words, it's a website built for both students and DSOs.
Okay.
Okay, try that.
Thank you, sir.
You're welcome. Good luck.
Thank you.
Oh, there's one more question. This is from Colorado. Colorado, go ahead. Colorado. Area code 303. Okay. I guess we are done for the day, folks. I will see you again in 2 weeks. It's always a pleasure to talk to all of you. Take care. Bye-bye.